නායක මහත්මයයි. එතුමිය උත්සව සභාව අමතා කළ කතාව මේ.
To have been invited to be present this evening at this year's annual convocation of the Bar Association. There is no necessity for me to emphasize on the importance of this occasion, and suffice it to say that it is one of the foremost events in the Bar Association's calendar. Let me take the opportunity to wish the newly elected President, Mr. Vijayadasa Rajapaksa, and the rest of the office bearers a very successful and a fruitful tenure in their respective offices. It is felt an apt moment for me to express my sincere appreciation to the outgoing President, Mr. Shibli Aziz, and the rest of the office bearers of the Bar Association for their unstinted support given to me during the last year. That support alone was a great encouragement, and I am certain that both groups would continue to extend that support in their different capacities, and especially as members of this noble profession for the upliftment of our individual duties. The Bar Association of Sri Lanka is one of the most prominent and impressive organizations we have in Sri Lanka. Its uniqueness is dependent on many things, which includes the glorious, long-standing traditions which are second to none. It is with immense pride that I wish to state that the Bar Association had assisted not only the members of the Bar, but also the judges in upholding the rule of law and the administration of justice. As such, the relationship between the bench and the Bar, which had been extremely cordial, had lasted over so many decades. Having all this in mind, I think this is an opportune moment to place before you some of my thoughts based on a few issues I believe that has to be addressed, together with the generous support and the cooperation of the members of the Bar. All of us are aware that in recent times we have been enrolling large numbers of attorneys at law. It is heartening to see the young and eager faces, not only when they are before the Supreme Court to take their oath, but also when they make their appearance in court. I am of the fervent belief that they are our future stakeholders in the administration of justice, and it is indeed our joint duty to assist our young lawyers in every possible manner. However, one cannot forget the fact that along with the numbers that are entering the legal profession today, the conditions surrounding the practice of law are also changing. The increase in the numbers of lawyers in the country would undoubtedly divide up the practice, which would bring in numerous other complexities. It is with deep regret that I am compelled to refer to one such difficulty which we in the Supreme Court are presently saddled with, which is based on the large number of complaints received on a regular basis against the lawyers. Currently, there are 5 Supreme Court judges who are looking into these complaints before sending them to the panels which were earlier constituted for the purpose of inquiring into these allegations. Although earlier there were 7 panels appointed for this purpose, currently only 3 such panels are functional. We would therefore be making arrangements to appoint a few more such panels in order to look into these complaints expeditiously. Although these processes could be carried out both by the Supreme Court as well as the Bar Association, I think there is a deeper issue that we must address in this regard. Except for a very few, the majority of the complaints are made by the general public and by persons who had one time been the client of the attorney at law in question. Some of the complaints are baseless and malicious, and the only objective is to bring disrepute to the attorney at law concerned. However, there are other instances where we come across serious allegations that had been taken up against attorneys with sufficient material to substantiate them. Our concern is based on the second category, as it reflects badly of this noble profession. It is in the light of the above that I wish to suggest that in addition to the assistance given by the Bar Association in inquiring into the allegations made against the attorneys at law, it would be necessary to explore the possibility of commencing an awareness program, especially for the young attorneys, on their professional ethics and the conduct in the profession. The Supreme Court in 1988, exercising its rule-making powers under the Constitution, had made rules on the conduct for attorneys at law. They were prepared over 2 decades ago on the basis of a draft code prepared by the Bar Association at that time. Last year, a request was sent to the Bar Association through the then President to forward the suggestions of the members of the Bar to amend the Supreme Court rules, as I had appointed a committee in terms of Article 136 of the Constitution. I have been told that a committee is in the process of considering such recommendations to be sent to us. This would be an occasion for that committee appointed by the Bar Association to consider fresh rules on the conduct of attorneys at law as well. The next matter which I wish to bring to your attention is something which the Judicial Service Commission had been working on for a few months since June 2011. Several actions have been taken to expedite the process of clearing the backlog of cases throughout the country. I have been speaking of this process ad nauseum at the Judicial Service Commission with the Ministry of Justice officials with regard to necessary funding for the process, with relevant funding agencies, and most importantly, with the judges. Several steps were taken to expedite the hearing of the cases which have been pending for over a long period of time. The judges were sent for training, meetings were held, several discussions had taken place, and currently we are in the process of preparing guidelines to be given to the judges, not only for the purpose of clearing the backlog, but also to ensure that timely steps are taken to avoid the creation of such backlogs in the future. It has also been decided that whilst taking all possible steps to conclude the cases which have been pending for over several years, that a procedure should be laid down to take up the other cases also without any undue delay. All our judges have been extremely cooperative in this process and had extended their fullest support. I am fully aware that several of our judges had taken innovative steps and had taken the trouble to walk that extra mile to avoid undue delays. However, this process has only just begun. We have so much to do and many miles to cover before we can even expect to see a shimmer of light at the end of the tunnel. To do so, we would need to muster all possible support to reach our objective. I would take this opportunity to make an earnest request from all of you to support the judges of this country in our sincere endeavor to draw to a close this unnecessary and unwarranted delay in our judicial system. Our justice system is closely related to the bench and the bar, and the success of this venture would exclusively depend on the support that would be given by the members of your esteemed association. Speaking for myself, I have every confidence that individually and together as a group, that all of you would give your fullest support to our endeavors in clearing the backlog of cases within a short time span. Those thoughts would bring me to the final point I wish to place before you this evening. I do not think that it could be disputed that socially, economically, and historically we are at an important juncture. The judiciary, being one of the 3 important pillars of the state, has a duty cast upon it to look beyond the frontiers in its proceedings with the administration of justice. It has been increasingly acknowledged that in order to uphold the rule of law in a democratic society, that it is necessary to have an independent judiciary. The judicial independence could be given different definitions and could take a variety of forms, but the underlying theme would be that the judges would act independently. Such independence is assessed for a variety of reasons, which includes public confidence, which is essential for the effectiveness of the court system. However, there cannot be an independent judiciary without an independent and a fearless bar in a country. It brings to my mind the interesting dialogue between the Chief Justice Rehnquist of the United States and Chief Justice Lamar of Canada, which took place at the Duke University in the spring of 1991. In an answer to the question as to what institutions are fundamental to the preservation of a free society, Chief Justice Rehnquist had readily replied that it is an independent judiciary, whereas Chief Justice Lamar had responded by stating that it is an independent bar. A more precise reply, in essence, to the question raised would be that, considering the close relationship between the bench and the bar, you cannot have one without the other. An independent judiciary is a sine qua non for a functional democracy where the courts are regarded as temples of justice. It has been said that the lawyers are the pillars of that temple, and if the lawyers are removed, the temples would be without pillars and will easily crumble. It should also be borne in mind that in order to ensure the sustainability of an independent judiciary, it would be extremely necessary to have the support of an independent bar. It brings to my mind the sentiments expressed by Justice Bhagwati, as he then was, in Gupta versus Union of India, where he had described the profession of lawyers as an essential and integral part of the judicial system. In Justice Bhagwati's words, the lawyers are really and truly officers of the court in which they daily sit and practice. They have therefore a special interest in preserving the integrity and independence of the judicial system, and if the integrity or independence of the judiciary is threatened by any act, they would naturally be concerned about it because they are equal partners with the judges in the administration of justice. The necessity for this interwoven relationship between the bench and the bar is very much felt at this hour, where the judiciary is striving hard to build public confidence. I am confident that the judges would get that unstinted support from the members of this noble profession. That support is necessary for the judiciary, for our judiciary, to become a formidable protector of individual liberty. I assure you of my wholehearted cooperation in all your future endeavors for the upliftment of the administration of justice. Thank you.